Oh, I've had the sentiments of my colleagues in Pretoria. Perhaps I can drop the second application, save the court's time, so that would be the first application. But I know for a fact that charge sheet is currently being approved, but I don't think there will be any trouble in arresting the accused person. A warrant of arrest can be issued later if they are not within the court's premises. So we can just deal with the first applications.
Then in light of her concession, they proceed with the first one, and they want to arrest if they have any charge sheet as alleged, then we can deal with it at that point.
There should be no orders. Your Honor, the state has decided to cede ground and to clearly tell you that the application that they brought before you was an infertile imagination. Your Honor, when you look at some of the reasons that were given to you to detain the 8 innocent accused persons, then you will realize the unseriousness of the DPP in this matter. Where is that? One of the reasons, Your Honor, you are being told that the accused persons were to be detained for a further 10-day period because an ID parade was to be conducted. And Your Honor, up to now, up to today, an ID parade has not been conducted. Your Honor, why would the prosecution come before this honorable court to lie to this court? We even know the circumstances under which an ID parade should not be conducted. And in the same affidavit, they clearly stated that the accused persons, the arrested persons, were allegedly searched and found with pangas and rungus. Found with pangas and rungus, allegedly, which means that they were caught in the act in flagrante delicto, caught red-handed according to them. That alone, Your Honor, ought to have disqualified the idea of the ID parade. And that, Your Honor, you are told that the arrested persons had no fixed abode. Your Honor, the state has enough machinery to identify, including but not limited to even tracking. During the Gen Z protest, these officers were illegally even tracking phone numbers and abducting these same people. And so the idea of a fixed abode, Your Honor, should have not been a sufficient reason. Because these were churchgoers, God-fearing men of God. They were arrested in church, Your Honor. And the police officers are just here looking at us. What a shame. Your Honor, the prosecution asked for 10 days. 10 days. 10 days to conclude the investigation. 10 days. Number one, 15 days were granted. And that leads me to speak to the spirit of Article 159, Article 159 on the administration of justice, Your Honor. Prosecution comes before you, Your Honor, to ask for 10 days. Then the court in its own wisdom found it fit to grant 15 days. Your Honor, justice administered under pressure ceases to be justice. Justice administered in fear ceases to be justice. Justice administered to satisfy the executive ceases to be justice. And there is only one standard measure for justice, and that is the constitutional justice. Your Honor, justice denied, justice delayed is justice denied. And today we are experiencing this scourge of justice. These gentlemen are innocent before this competent court of law under Article 50, Subarticle 2A, the doctrine of innocence until the contrary is proved. Your Honor, Article 157(11) speaks to the heart of the DPP. But the DPP should act in a manner that promotes public confidence. What is before you today here, Your Honor, is DPP acting in a manner to promote self-interest. Why self-interest? Because up to now, Your Honor, 10 a.m., there is no charge. We are being told that it is yet to be approved, Your Honor, yet to be. 1 second of detaining these innocent Kenyans denies them their constitutional right to liberty under Article 29 of the Constitution of Kenya. Right to liberty. And liberty is the grammar of life. Your Honor, jail term starts with 1 day, 1 second. Jail term starts with 1 second. 1 minute is so much time if a person spends in jail or in a police cell. That amounts to detention without trial. Your Honor, a right to fair hearing is being tested before you, and history will remember you, Your Honor. And we shall give examples that at some point we were before you, Your Honor. Article 52 talks about right to fair hearing. Your Honor, do not allow your court to suspend that right just to satisfy the state. Your Honor, today we are not here This court is not trying the charges that you are being told, allegedly, that are yet to be brought before you. These allegations, if they are there, will await trial, Your Honor. Today, this court is testing something else, Your Honor, something else and very important. And that is the Constitution itself. The Constitution itself, Your Honor. So will Article 49, Your Honor, survive this political heat before you? Or will it become a fair weather promise? Your Honor, these accused persons cannot surrender their constitutional right. Not even at the police station, cannot suspend and cannot surrender their constitutional right. Not even at the door. The Constitution is meant to protect them where they are as we speak. Your Honor, history will remember judicial officers who defend the Constitution, who defend the constitutional principles when doing so was unpopular. Already, Your Honor, 10 days were asked. The court, in its generosity, grants 15 days. Days that were never asked by the prosecution. And the Constitution of Kenya deliberately places liberty before conviction. Liberty before conviction. Because it presumes innocence before punishment. Today we are punishing 8 innocent Kenyans. Your Honor, by asking for 10 days, because the norm should be investigate, arrest, charge. Today, arrest, come to court, ask for 10 days, court gives you 15 days, then come back to court and say that our charge sheet is not ready. Your Honor, what type of a country are we living in? History will judge all these, Your Honor, and we shall live never to forget what is happening today. Your Honor, therefore, it is my prayer that you close this file. You close this file. We had a matter, as the senior counsel has mentioned, of treason, an alleged treason. The magistrate, in his own wisdom, closed that file and told, close the file, ashamed the levels, and told the DCI never to joke with justice, Your Honor. We are all equal before you, Your Honor. Therefore, kindly release these innocent Kenyans. Thank you. Without any condition, Your Honor. If they are ready with their charge sheet, we will come back for you. We are available. Because you are our meal. We want to dine. We want to feast on you. Thank you, Your Honor.
My lady, I think my colleagues have said enough on the matter, but just to add, we should not allow the judiciary to be used as a tool of repression and frustration for normal Kenyans into the criminal justice system. Because this is a trick we have seen from 2024, where a lot of our young innocent Kenyans were bounced between courts to courts to ensure that they are frustrated, they do not exercise their constitutional rights. Just looking at this against the prosecution, because they should not come before you if they are not sure of what charges they want to levy against this given individual. It was indicated they were supposed to go through a raid, they were supposed to go through DNA analysis, but now all of them has been cancelled and saying they should not issue different charges because they have seen they have already wasted the court's time and held them for over 15 days. Now they want a new case they want to give. My lady, we should never allow the criminal justice system to be used as a knife against the very Kenyans that this constitution was aimed to protect. The justice system and the courts have always been known to be the halls that defend the weak, defend the innocent, defend the poor. My colleague has said that we truly are equal before the law, but the law can also be used as a tool of repression and creating justice. And therefore we urge that these innocent individuals should be released immediately and they should be allowed to enjoy their right to liberty. Our courts should always uphold the very basis of our constitution under Article 50, that you're innocent until proven guilty. Let them prove their case. Let them not use this cause that's supposed to be sacred as a tool to ensure repression, as a tool to ensure frustration. Kenyans have been crying about whether they can get justice in our courts, whether they can trust in the dignity and integrity and independence of our courts. And so we ask you to ensure that that independence should be spoken loud and clear, that our courts shall never be used as a tool to ensure frustration, but rather as a hallmark of justice. And we defend always the poor and the vulnerable. And therefore we ask that, and it's our humble prayer, that they will be released effective immediately with no further conditions. Thank you, my lady.
Your Honor, sorry once again. We pray that the ruling be delivered extempore, because of any justice delayed still amounts to justice denied. Thank you.
Your Honor, in conclusion, I just want to talk about two things. We should ensure there is no abuse of the court process. And I'm saying this because before you, there was a submission that the respondents are likely to interfere with witnesses. It is quite law that on that issue, the prosecution should not make any submissions which is not supported by evidence. Material evidence to demonstrate that they are immoral. The respondents are likely to fit their flight risks. Normally, a judicial court cannot make a judgment on that question without material evidence. So what is the court to do in these circumstances that we find ourselves in? I think one, as has been prayed by the prosecution, is to close the file. And secondly, because there's been an abuse of the court process, in effect that there was going to be a charge and there's no charge, and the prosecutor has clearly indicated that the respondent should be held until a charge is filed before the court, a charge which has not been approved. We pray that you make an order that when such a charge is filed before the court, because the charge has not been approved, but if such a charge has been approved, I'm ready for registration of file in court. The respondent should be served with summons to appear. Either to counsel